Hello uh, and welcome to my presentation. I am going to talk about the legal aspects of AI, whether things that we do with the AI are within the legal framework or not. My name is Lucie Malá. I am a legal specialist in Legitas.cz. And since creation or formation of the Czech AI Association, I am quite busy with the legal aspects of it. This is my background. I studied and worked in the Netherlands at the University of Groningen. I studied law and technologies, and at the moment I am dealing with this topic at the University of Tilburg. And I also studied at the law faculty of the Czech University. So, back to our topic. At the beginning, I prepared a small case. Philip used an application called Undressed AI and created deepfake naked pictures of his ex-girlfriend. He sent her these pictures and threatened her that if she doesn't pay 20,000 crowns to him, he will publish them on social media. And the question is, can we help using existing law deal with the misuse of artificial intelligence? So, an answer is, what can we do? We can't do much, but we still can do few things. We can use already existing articles of criminal law. For example, Article 175, blackmailing, Article 181, damaging of law of rights of third party, Article 184, mistalk. And then we have also the civil code. So first message that I would like to transfer is, it doesn't matter if you have a knife in the kitchen, but what is important is whether you use it to cut a carrot or stab your flatmate. So AI is a tool, and if you use it outside legal framework, of course you can be prosecuted. So what are rules, and what type of rules do concern AI the most? So we have AI Act, which concerns mainly personal protection, criminal law, GDPR, intellectual property rights, contracts, and internal rules. And concerning schools, I have prepared some examples which are the most burning at schools. First is the copyright law. And the basis of copyright law is that creative and individual work piece created by a person is protected. And we cannot use this type of work piece without asking. And this protection lasts for 70 years. For example, if you have a perfect picture, you share it on Instagram, and somebody takes it and uses it on his Instagram, you are protected and you can prosecute this person. So this is a violation of the copyright law. Where do we see this problem in the AI world? The problem is that first we have to ask, do I violate copyright of somebody else when I generate AI? So if I generate my work, then the final result can look like a work piece of somebody else. For example, this picture that you can see, somebody wanted a picture that would generate magician's artifacts: head, scarf, an owl, and some books. So this reminds me very much of the Harry Potter world. Even though the person who did this prompt, who asked for a picture on the basis of these pictures, the generated result very much reminds of Harry Potter world. So when this happens, you must be careful whether the result doesn't look like something which is protected by copyright of someone else. And this problem appears at school as well. It is a problem when this picture is used in a presentation of a student or a teacher. So, is it a problem at school? Yes or no? No, because if you use it in education, then there is an exemption. Typically, if you use AI-generated work pieces which are protected by copyright, they can be used because education is an exemption. But be careful, it can be a problem if you use it somewhere else. So, second message that I would like to mention is the outcome of generated AI can remind somebody else's work piece. We stay with the Copyright Act. I have mentioned work piece several times. So copyright protects work pieces, but not everything you create is a work piece according to the copyright law. It has to meet several criteria. First, it has to be unique, it has to reflect the creativity of a certain person, and it has to be understood in its visual aspect. And then in the world of AI, we have a problem number two. When is a work piece created? For example, you prompt, i.e. you ask a question to the AI, and then you get some outcomes, and you don't know whether they meet the three criteria of what is the definition of a work piece. So then we have to answer the question to what extent the work piece was generated or outcome was generated by an AI, or whether there was a certain creativity of someone. Or if you, for example, use something that was generated by AI, you put it into a Photoshop and then you work on it. So is it your work piece or is it not? And why do we want these things being protected by copyright? Well, at school it's not such a huge problem. You can generate a picture for your education purposes. Student generates a picture to show it to the teacher and vice versa. There is an exemption. You don't need to pay attention to the three rules. But for example, in terms of marketing, if you are a creative expert and you create a logo of a company, then can anyone steal this logo or not, because it was generated by AI? So is it a work piece or not? Because if it is not a work piece in its definition, then anybody else can take it and use it. So my third message is that an outcome of generated AI doesn't have to be considered a work piece, and therefore it is not protected by copyright law. And now I am moving from the Copyright Act to the category of internal rules. In our situation, it is, for example, the study rules of the Unicorn University, but it can be internal rules of a company where you work. It can be again internal rules in a company where you work. Simply everywhere where you work, the organization has its internal rules. And I had a look on the internal rules of Unicorn University with regards to AI. So you don't have anything specific, but there are a few items that are interesting. For example, it says that one of the fundamental pillars of working with AI is transparency. Students must always disclose that they have used AI tools in their work, especially when writing their thesis. It is important to clearly state which parts of the thesis were created with AI support and how. Failure to disclose the use of AI may be considered a breach of academic integrity, similar to plagiarism. So for me, this is a very important rule. And of course, you probably didn't expect that in a presentation of legal aspects we would be looking at the study order. But this is something that someone can demand that from you. It is important to pay attention whether your school or your employer has rules and will request you to meet the rules and criteria. So that was from the perspective of a student. Now from a perspective of a teacher. So the teachers should set specific rules that can be used during the studies. But when the teachers or educators set clear rules, then the teachers must require the students to keep the rules. And then what concerns educators or teachers as well, then they should stay cautious when using freely available AI tools. So this is very beautifully stated, and I would like to appreciate this here at Unicorn University. So message number 4, internal rules of the school are rules which are expected to be requested, and that's why it's important to know them. So you should always know the rules of the game which you play, whether it's school or whether it's your company. Then this is the third area. After copyright and internal rules, I would like to say a few things about data protection. This is mainly GDPR, the conditions of use, and obligation to remain silent. And can AI keep a secret? Can AI be can keep a secret. So AI, if you generate something, you have to or if you want to, you have to click that AI will not use your data. And this is in the contractual rules, and the contractual rules are just rules that can be violated. So what we propose or recommend is, if there are data or information which should be kept secret, you should not enter them into AI. When it comes to personal data, this is mainly in the area of the teachers, which is name, phone number, etc. And if you do not have any provision that you can do it, you should not do it.
If you have signed an NDA with somebody, you are, for instance, contractually bound to your employer that you will never disclose your salary, and then you input this information, which is protected, into AI, this could be considered a breach of contract. A breach because you disclosed something that you were obligated to remain silent about. Maybe this wouldn't be disclosed, but then perhaps somebody tells on you, and it could constitute a breach of confidentiality. And it is a question where the data that you input flows, how much you trust the AI provider. And my message would be, don't trust too much to the AI providers. What you're being promised is just contracts, and you yourself have for sure encountered a lot of instances of contractual breach. This is a sort of a summary of what I shared with you. It's 5 main points. One is that AI is still just a tool with the same rules as that apply to it as any other tools. If you hurt somebody using AI, it is the same thing as if you hurt them using any other tool. The second point is that the output from generative AI can resemble somebody else's creation to such an extent that it will be violating the copyright of its author. Third point is that the output of generative AI may not be considered a creation as such, and thereby not be protected by copyright. And the most important to me is that internal regulations of a school is something that you should really interest yourselves in, especially when it concerns AI. The rules that you see are the most probable ones to be enforced, so you really should read them, acquaint yourselves with them, and implement them in your daily life. And point number 5, do not put too much trust in the AI providers. I wouldn't share any secret personally. That is all from me. Thank you very much for your attention. This is a topic that I write about on LinkedIn, so you can join me, even ask me questions there, and I'm already looking to your questions here. There are many questions also from the audience. I will try and ask them one by one. One thing is the similarity that you mentioned. I generate something using AI. Somebody is asked about a person that could be similar looking to somebody else, but I have 6 billion people. It's very hard to evaluate whether the avatar that I've created is similar to one of the 6 billion. So what to do? The student, by the way, that you used in your illustration of read the rules looked a lot like Gandalf. But that's just to the side. So I generate something. It's very hard to evaluate. Is it similar to something? Should I ask the generative AI to evaluate? Because the border of legality is quite tricky here, and it's hard to judge whether I can use it or not. What we advise most is to give it some thought. This step that you are talking about. Whenever I generate something, the first thought should be, is it similar to something? Is it breaching some sort of a rule? And if you give it the thought, there is a sort of a test of how a common, like any other person, a regular person would see this. You can ask people around you and they say, "Ooh, this looks a lot like Billie Eilish," so you know that this is maybe not the best idea. But what if what I've created is similar to some guy from New Zealand? That's very hard to judge. Yes, but we are mostly looking at breaching the rights of known personalities. So if you maybe use your creation in a demeaning manner, if you put this creation that resembles the famous personality on a T-shirt, that would again breach their rights. So we are mostly looking at a personality that is well known, and whether you use it in such a way that could defame them or use it in a way that is not okay. This possibility that you mentioned, that it's similar to some regular guy somewhere, is rather remote. Okay, I know that I'm taking it a bit too extreme, but Maybe if this would be someone moderately known, okay, this would need some further looking on. Where do you see the weak points in your practice? Where do you most often bump against insufficient provisions or protection when working with the AI? Unfortunately, often many institutions realize that they need to ask themselves a question whenever they create something with the AI to look at the legal aspects of it. Oftentimes, this can be resolved with simply just brainstorming without any lawyers, but sometimes in companies, institutions, they don't even look at the legal aspects of this. There might be some GDPR issues. So this is a type of problem that is cropping up all over the place. So I really would stress that we need to look at the legal aspects. So let's say an organization wants to really look at this aspect, make sure they're not in breach. Where should they start? Is there a website that you would recommend or a methodology that covers this aspect? What would you recommend? At the moment, there's not that much AI compliance and a methodology of how to keep the entire company in compliance is not that well covered, because this is a relatively new topic. And of course, every institution is different, every AI is different, and the uses are also very different. So it's very hard to prepare a ready-made file or a set of rules. So AI compliance is a huge field in most organizations or institutions, that it is hard to recommend a specific place that they should always turn to. My next question is again rather general, again asked by our listeners. Let's say a company has some e-learning materials and somebody modifies them using AI, using some sort of media input, and provides these materials back as something that they have worked on. Let's say they have used AI, maybe even a paid version of AI. How is this covered legally? Because I have modified the creation using some tools. Maybe this is a copyright clash. Do you mean from the viewpoint of the owner of the copyright to the materials? I'm thinking maybe how to, could this be maybe covered contractually? Of course, a contract is step number one when you're using AI. You have some contractual like terms and conditions of use. And this is something that you should refer to whenever you're asking yourself what I can do, what I own, etc. And when people add to this or subtract to whatever creation, it is best to refer to this and cover this by contract, and to also specifically say where in the steps of the creation or modification AI was used, etc. Thank you very much for your valuable input.